Let's do a quick review of the federal court system. The federal court system is divided into 13 circuits, numbered 1 through 11, plus the Federal Circuit and the District of Columbia Circuit. Each circuit is comprised of one to several federal districts, named geographically, for an example, the District of Nevada. Litigation in the federal courts is governed by several sets of rules. The Federal Rules of Civil Procedure, the Federal Rules of Criminal Procedure, the Federal Rules of Appellate Procedure, the Federal Rules of Evidence. These are supplemented by local rules in each individual court and standing orders from each individual judge. In short, there are tons of rules litigants must comply with anytime they're in federal courts. Let's now talk about an essential part of the federal court system, the concept of limited jurisdiction. Fundamental to federal courts is that parties can only bring certain types of cases in these courts. In fact, the vast majority of cases in the United States are filed in state courts or other courts such as agency courts. In every case, the first thing the judge and clerks do is ensure there's personal jurisdiction, which is jurisdiction over the parties, and subject matter jurisdiction, which is jurisdiction over the subject matter of the dispute. Either the claims arise from federal law or diversity is met. It's also important to remember that the federal court system is about much more than just the traditional trial and appellate courts. Of course, you are familiar with the U.S. district courts, where the case is actually tried, and then the federal appellate courts, or review the trial courts, and of course the United States Supreme Court. But there are loads of other courts, such as bankruptcy courts, tax courts, various administrative courts, immigration courts, and many others. It's also important to remember that there are a number of different types of judges in the federal system. Each has distinct and often overlapping jobs. For example, the courts would fall apart without magistrate judges, who handle a number of important things from arraignments to discovery motions. Administrative law judges handle loads of requests and petitions. All of these judges are real judges, they issue real orders and opinions, and they are absolutely essential. It's important to keep in mind here that there are some key differences depending on whether a case is civil, such as a contract dispute between two businesses, or if it's a criminal case, such as if the government charges someone of bank robbery. Let's first review the timeline of a civil case. First, to initiate the case, someone files a complaint, usually because they think they are owed some money, for example, because someone breached a contract with them. The next big phase in the case is discovery. This is often the longest phase in the case, and depending on the type of dispute, can go on for months or years. Magistrate judges handle the bulk of these disputes. Then there are often early pretrial motions, such as motions to dismiss. Later in the case, before trial but after discovery, the parties will often move for summary judgment on some or all the claims. If the case survives to this point, the parties will then duke it out in trial. If it's a jury trial, the parties will present their arguments to the jury and wait patiently for a verdict. Now, if the plaintiffs win, they will get a judgment and then may try to enforce it. If the defendant wins, the case is largely over unless the defendant appeals the decision. But, inevitably, one party is always unhappy at the end. They will often appeal for a new trial or to get review from the higher courts. But the most common way that cases end in the civil litigation context are by alternative dispute resolutions, such as settlement. In some ways, criminal cases proceed very similar to civil, but there are critical differences. For an example, there are some additional proceedings in terminology. Instead of a complaint, the government eventually indicts the defendant by grand jury, typically, then there's an arraignment and plea. The parties often bring motions related to pretrial and post-trial detention, obviously not an issue in the civil context. Discovery in criminal cases is much more limited than civil cases, and the prosecutor has a number of special obligations to disclose information that can help the defendant's case. Pretrial motions are also very different in criminal cases. There are not motions for summary judgment. Instead, parties will move to dismiss the indictment because of some defect or constitutional violation, or move to suppress evidence. Trial is also carried out very differently in the criminal context because criminal defendants get protections civil litigants do not. Then, if convicted, there are a number of legal and factual issues to settle in the sentencing phase. Like in the civil context, alternative dispute resolution in the criminal context, commonly called plea bargaining, is extremely common. In addition, in criminal cases, the Speedy Trial Act adds additional complexity. This act requires cases to be brought to trial within a very short period, subject to some exceptions. Now, often the losing party in a civil or criminal case will appeal. The parties will first submit briefs explaining how the trial court got it wrong. The appellate court will sit in panels of 3 or larger groups and render a mandate or decision. Typically, this is where the case stops. But the last chance for a losing party is to appeal to the Supreme Court. The Supreme Court chooses a very small number of cases to review each year, usually because the case concerns some important question of law. This should give you a general idea about how the federal court system works.